He believed power was limited, not absolute, and that power always resides with the people, always. Now, over 200 years later, today's Supreme Court decision, once again, it will depend on the character of the men and women who hold that presidency that are going to define the limits of the power of the presidency, because the law will no longer do it. I know I will respect the limits of the presidential powers I have for 3.5 years, but any president, including Donald Trump, will now be free to ignore the law. I concur with Justice Sotomayor's dissent today. Here's what she said. She said, in every use of official power, the president is now a king above the law. With fear for our democracy, I dissent. End of quote. So should the American people dissent. I dissent. May God bless you all, and may God help preserve our democracy. Thank you. And may God protect our troops.
Leading off our discussion tonight is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Professor, it's the summer break at law schools, but I'm imagining students returning to constitutional law class in the next semester. And what just happened to constitutional law?
Well, it was rocked to its very basis. The Supreme Court of the United States turned the Constitution upside down in a very profound sense. The most fundamental principle on which the Constitution rests is that the law binds everyone, and the Constitution elaborates the structure of that law. Although it does contain some provisions in the so-called speech and debate clause for immunizing senators and members of the House in certain limited circumstances, it doesn't give any immunity from ordinary criminal law to the president, the most powerful figure in our government. On the contrary, it is because he has such enormous power that he, like anyone else, must obey the criminal law. There are some people, including people at the Justice Department, who've written rules saying that you have to wait until the president leaves office before commencing a prosecution for crimes he commits while he's in office. But until today, no one has seriously claimed that absolute immunity for certain official acts would apply to the president. As Justice Jackson pointed out in a very powerful dissent, she dissented in addition to Justice Sotomayor. Justice Kagan joined the dissents. But Justice Jackson, in a very powerful dissent, said this whole business of drawing a line between official acts and unofficial acts, and saying that if you're on the official side of the line, the president can essentially get away with murder. It's on the unofficial side that he might be prosecuted. She points out how that gets it upside down. It is exactly when the president is using the official powers that belong uniquely to that office that we should be most worried about the president becoming an autocrat, or as Donald Trump told us he wants to be on day one, a dictator. So the court has it backwards. It is true that the case will go back to Judge Chutkan. She'll hold hearings. Some think that's kind of a silver lining because those hearings can begin soon, and the nation can perhaps see much sooner than it otherwise would if there had been a trial in the fall. The nation can see more of the evidence about what Donald Trump did in the fake elector scheme and in the violent mob that he riled up. But that's a pale substitute for what the people are entitled to, and that is a verdict, guilty or not guilty. Is the president guilty of, for the first time in our history, organizing an effort to prevent the peaceful transfer of power to his successor. That we won't have. People will be going to their voting booths and deciding whether to vote for someone who has already abused these powers, as opposed to someone who, though the powers have been handed to him, says, I don't want to use them. I believe in the rule of law. Voters will be making that choice without the evidence they need.
I want to read Justice Ketanji Brown Jackson's the conclusion of her opinion. She says the majority of my colleagues seem to have put their trust in our court's ability to prevent presidents from becoming kings through case-by-case application of the indeterminate standards of their new presidential accountability paradigm. I fear that they are wrong, but for all of our sakes, I hope that they are right. In the meantime, because the risks and power the court has now assumed are intolerable, unwarranted, and plainly antithetical to bedrock constitutional norms, I dissent. Dissent language doesn't get stronger than that.
Well, the language couldn't get stronger because it deserves to be enormously strong. That language was uttered just 3 days before Independence Day. In several days, we will celebrate the nation's survival of a revolution against kings and queens. We had a revolution so that we wouldn't have a king, and now the Supreme Court says, that's what we're giving you. I don't think we should accept that present, but it seems to me that all that does is basically put the court on the ballot this November. We have to decide whether we want the kind of government that Donald Trump has helped us have by appointing 3 members to this court, because 3 of the members of the majority were appointed by him, and 2 members of the majority ought to have recused themselves, Alito and Thomas. Mm-hmm. That's 5 justices. And it's those 5 who ultimately decided that even the evidence of official acts couldn't be used to show what the president was up to when he used his official powers. Because motive supposedly doesn't matter, but motive is everything. Whether a president gave a pardon in return for a bribe depends on whether he was doing it as a corrupt matter or whether he was giving a pardon because he thought someone deserved mercy. As Justice Barrett pointed out, you can't really make sense of the quid without the quo, and yet under the incoherent decision of the majority, you can prove the transfer of money, but you can't prove anything about the pardon that was given in exchange. That's the kind of thing that makes this decision so incoherent. And what makes it really dangerous is that even if we eventually get over Trumpism and the MAGA movement, we will have to rely on the good character of future presidents, because the law will no longer serve as a source of inhibition. That's dangerous. That's a prescription for autocracy and eventually for authoritarianism and dictatorship.
Harvard Law Professor Lawrence Tribe, thank you very much for starting off our discussions on this historic night.
Thank you.
Thank you.
Thank you, Lawrence.
And coming up, Neil Katyal, Andrew Weissman, and Melissa Murray will join us with their view of today's Supreme Court ruling. Joining our discussion now, Neil Katyal, former acting U.S. Solicitor General, who has argued over 50 cases before the United States Supreme Court. He's professor at Georgetown Law and host of the podcast Courtside with Neil Katyal. Also joining us, Andrew Weissman, former FBI General Counsel and former Chief of the Criminal Division in the Eastern District of New York. And Melissa Murray is joining us. She is also an NYU law professor, as is Andrew. They are the co-authors of the New York Times best-selling book, which I used tonight, The Trump Indictments, the Historic Charging Documents with Commentary. All three, of course, are MSNBC legal analysts. Neil Katyal, with all of your Supreme Court experience, how much of this did you expect?
Almost none of it. This is a decision that was, I think, wrong start to finish. One that really, I think, changed our Constitution dramatically. So both procedurally and substantively, I'm frankly shocked. Substantively, the idea that a president can do whatever he wants, including and up to sending out Navy SEAL Team 6 to assassinate his political rival, is certainly not the Constitution that I've ever understood. It's not the Constitution of the United States. This court's decision goes way, way, way too far in giving the president basically carte blanche when it comes to executive powers. There are some bright lines and the bright silver linings in there about, for example, the president's role over state legislatures and assembly of fake delegates, which I think that the court leaves possible to prosecute people like Donald Trump for. But in general, when it comes to presidential powers, this is not the Constitution that I have ever understood it to be. Procedurally, I would have expected a unanimous decision or close to unanimous. That's the way the court traditionally operates in hot button cases like this. If you go back to, for example, the Nixon tapes case, which was, almost unanimous against Nixon and rejecting his claims of presidential privilege, which was just a weak cousin of what Donald Trump sought here. Even Nixon's own appointees to the Supreme Court ruled against him. Here, by contrast, you have the 6 Republican appointed justices, all siding with the Republican nominee for the presidency, Donald Trump, and you have the 3 democratically appointed ones siding the other way. That is not the place the court should be. It's not surprising that we've already heard from President Biden about this, and I expect in the days and weeks to come, the court will become the front and centerpiece of the election. I think Biden will run against the court more than he'll run against even Donald Trump, although the two now are locked kind of at the hip, Trump and the Supreme Court. So this is a tremendously unfortunate ruling, Lawrence, and one as to which I was shocked.
Yeah, I think so many of us during our lifetimes have come to expect so much of the court because we saw the court deliver in circumstances that proved the court's integrity. The Republican President Richard Nixon proved the Supreme Court's integrity, and now former Republican President Donald Trump has disproved it. Andrew, without that Supreme Court decision in the Nixon case, we wouldn't be sitting here so stunned tonight as we are.
Yeah, look, as we talked about off air, in many ways, this decision sort of quietly reverses the entire logic of the Nixon tapes case. Because you have this broad recognition by the Supreme Court that anything that is within a very expansive view of the core functions or the take care clause of the Constitution is completely and 100% absolutely immune. And then even other official acts, there's a strong presumption where the court sets out a very difficult test to allow the government to go forward. But let me just make sure people understand, with respect to that core function where the court says it is absolutely immune, they say one of the things within that core function is the communications and the directions of the president and the Department of Justice. So they say that when a president orders sham prosecutions, he can do that and not face any criminal repercussions. Just to say it is to be shocked by it. I am completely with Neil. This is such a transformational decision. And finally, the tape that you played of President Biden is so remarkable because you have the sitting president saying, "I do not want that power. I should not have that power. That is not how our system works. The sitting president is saying this is not part of the checks and balances that we have in this country. We are not an autocracy. It is remarkable, just as an institutional and historical matter, that you have President Biden on the day of the decision saying, I do not need and I should not have that power.
Melissa Murray, you clerked for Sonia Sotomayor. She made the point in her dissent that every president prior to Donald Trump, every one of them assumed that criminal law applied to them, every one of them. They were not inhibited in any way as presidents, as law-abiding people are not inhibited by the fact that law applies to them. How do you think Justice Sotomayor has been dealing with this opinion and the length of time it took to get it out? What was going on? What can you imagine going on inside the court to take this long?
Well, Lawrence, I don't think we have to imagine it. I think she told us a few weeks ago when she received the Radcliffe Medal in Cambridge, Massachusetts, where she said that there are days where she goes back to her office and she cries because this court, of which she is a member, has done something so shocking, so beyond the pale, that it beggars belief. And I think this is one of those days. She chose to read her dissent from the bench. Again, that is an unusual step that they take only when they feel that it's really necessary to impress upon the public how monumental the majority's views are. She also, I think, quite rightly noted that this is a major hit to democracy. And she noted that she did not respectfully dissent. She simply dissented, noting the bad and sad times for democracy ahead. I wasn't entirely shocked by this decision. This is a Supreme Court that has had a 6-3 conservative supermajority for about 4 years. And in 3 of those 4 years, it has overruled a major precedent every single year. Dobbs in 2022, the affirmative action cases in 2023, the Chevron case this year. And now it's essentially abandoned Nixon versus United States. It's not done so explicitly, but this is a sub rosa overruling of Nixon. Who would have ever thought that we would be in a position like this, where the Supreme Court of the United States, so emboldened by its mere numbers, could simply run roughshod over the rule of law, over stare decisis, over existing precedents? That's what Donald Trump put in place. And I agree with Neil. I am surprised the Biden administration has not taken a more strident view about this court and its role in constructing the current landscape that we live in. But this is not just about the threat that Donald Trump poses to democracy. This court by itself is an existential threat to democracy.
Let's
Lawrence,
all just go ahead, Neil, quickly. We'll go to a break after that.
If I could just pick up on that.
Please
I
do.
mean, the most important book in constitutional law is Alexander Bickel's book, Least Dangerous Branch. And the argument of the book is that the court does its best by not doing a lot at any one time. It conserves its legitimacy. And what you have here is the opposite, what Melissa elsewhere has called the YOLO court, which they're overruling precedent after precedent after precedent because they have the numbers. And what Bickel predicts is the institutional collapse of the Supreme Court and its legitimacy. And unfortunately, that's what we're now seeing. And it's the court's fault. They're putting themselves in the headlights of all of these major decisions like the ones Melissa mentions.
This opinion does read like a mess, and the question is, how big are the holes in it, and how much can Judge Chutkan get through those holes? We'll take up that question after this break.
OJ.
Neil, the Supreme Court in the majority opinion says the president is a branch of government.
Absolutely. It's a branch of government, but that doesn't mean that it's a branch of government that exists exogenous to law. And the idea that a president could do the kinds of stuff that you read in paragraph 74 on pressuring the Justice Department to impugn the election and install his preferred candidate for acting attorney general to do that is so dangerous. And here, Lawrence, I want to remind everyone of Justice Jackson, not Justice Ketanji Jackson, but Justice Robert Jackson, Jackson, because when the Japanese internment case came up to the Supreme Court, he dissented, saying, look, the power the majority is going to give here to the president is going to lie around like a loaded weapon for some other president to pick up and use in some horrendous way. And I fear exactly that about this decision. This is not just about Donald Trump. This is not about Joe Biden or Merrick Garland or Jack Smith. This is about the most fundamental thing we have as Americans, which is life under the rule of law. The idea that no person's above the law. The idea that a president can't act exogenous to law, that he's constrained by the law. And what the court did today is blow past and destroy that fundamental underpinning of our system. I don't think this decision's going to last. I don't think that we will have 5 or 6 justices in the future who can sign on to what is basically nonsense. It's it's not America, and it shouldn't survive the test of time.
Neil Katyal, Andrew Weissman, and Melissa Murray, thank you very much for joining us for the most important discussion this program has ever had about a Supreme Court opinion. Thank you very much.